Good morning. Welcome to the joining us. Thank you for joining us for this webinar this morning. We'll get started in just a moment. We're just giving folks a chance to get settled in. Just a reminder, you can follow us at Oregon Realtors on all social media outlets. Keep track of what's new and exciting and hear all the updates coming out of our association. So today we are going to be talking about landlord tenant law. We're joined by Bradley Krause from Warren and Allen. Bradley is fantastic. He does many of our or all of our landlord tenant law updates, and today he is going to be covering a few exciting topics, including the new laws on rent increases. Whoopsie, sorry, I lost my notes. Give me 1 second. Here we are. All right, so we're going to be understanding the new Oregon's new non-payment notices and timelines, understanding notice pitfalls and issues with those both as to forms and cooperation with rent assistance, and understanding new rent increase rules set to be enacted shortly. So with that, I just want to give a few little housekeeping reminders. If you need technical support, the tech helpline is free to all Oregon Realtors members for any of your tech issues, from you can't get an app to work on your cell phone, to your printer isn't working, to you're having trouble in this webinar. You're welcome to call the tech helpline at 888-804-8226. I highly recommend saving that in your phone. If you have any questions for this session, please feel free to use the chat and drop your questions in there. For CE credit, you must be logged in with your name. So when you sign up for this webinar, you should have put your name in the registration form, and make sure it was your name. You will get CE. So if you are logged in as multiple people, so like two of you are sitting together and watching this webinar, the person who's logged in with their name will get CE credit for this. If you have any questions, please feel free to chat at Oregon Realtors in the chat, and we can help you with make sure you're getting CE. You must stay on for the full 50 minutes at a minimum in order to receive CE for this webinar. You will receive an email in 2 weeks with instructions on how to access your CE certificate. Okay, so with all that, I'm going to stop sharing my screen and kick it back over to Brad. Brad, thanks so much for being here today.
No problem. Thank you for having me. Good morning, everybody. Sorry, I was a little bit absent there for a hot second. I had to get some water real quick. As Erica said, chatting a little bit today about some new developments, some new and returning things in the world of landlord-tenant evictions. Erica, should I just jump right into it right now?
Yeah, absolutely. We're excited to hear about it.
Perfect. Okay, well, let me pull this over here and I can share my screen, hopefully. That way I can go through the lecture handouts with everybody. And there we go. Let's do this one. Whoops. Not that one. Stop sharing. I think I'm sharing the correct screen right now, right?
What's old and new, or what is old is new again?
Yep, that'd be the one. Yep. All righty. Cool. Well, the topic today, at least the initial part, is HB 2001. It is sort of it's the new kid on the block. It's been here since basically the start of April. And so we'll talk a little bit about what it means for your notices, for your evictions, and kind of the general process of how things are going these days. This handout was drafted by my colleague, Anna McCormick. She's fantastic. So if you can't get me for whatever reason, having her is just as good. She is fantastic as well. But all right, so the main change to HB 2001 is with respect to non-payment notices. Unfortunately, as the section says, goodbye 72s, hello again, 10-day non-payment notices. As you all recall, during COVID, the rules sort of changed. We had 72s long ago, and then during COVID, they switched the legislation to be a 10-day notice. And if you had asked me towards the end of the COVID times whether we were going to go back to 72-hour notices, I was of the opinion that no, we would not. I figured the legislature would make that a permanent thing, but we did. We went back to 72s for a little bit. And I thought that was all great, and I thought we were just going to maintain that. And unfortunately, the legislature button hooked on us, as the lecture handout states. It was more of a Tom Brady unretirement. 5 months later, the 72-hour notice is now permanently banned. So we are now permanently back with 10-day notices. Unfortunately, 72s are long gone. Because of that, and this is going to be a theme that you'll hear me say probably over and over again, because it's unfortunate that I see it here and there still, but I want to stress this. If you are using old forms, please ensure that you scrap those old forms and get new forms, get up-to-date forms, because there are certain things with the forms that are needed, that are necessary, and we'll talk a little bit about those, but old forms are not going to have them. The old forms that you used during COVID are not sufficient, so do not use those. I've seen people try to do that. Do not do that. So yeah, that's the big takeaway here. There's a quick question here. Multifamily Northwest is the best location, right? There are several forms makers. I can't advocate for one over the other because I work with all of them. Multifamily Northwest, NAA has their own national apartment associations, and then the Rental Housing Alliance also has their own forms. All three are fantastic. All three are vetted by attorneys. So whichever you find that suits your interests or suits your needs the best, feel free to use those, but I can't advocate for one over the other. All right, as the lecture handout says, 10-day non-payment notices back here to stay. Unfortunately, they are, that's going to be permanent unless something changes in the legislature, which I highly doubt it will. The other important thing to remember, and we'll talk a little bit about what this means, is the CARES Act. Don't forget about the CARES Act. So while state law allows the service of that 10-day notices, if your property is a covered property, as defined by the CARES Act, that means you also need to comply with that federal requirement that notices must give at least 30 days to vacate. There's, with respect to the CARES Act, you've probably heard a little bit of kind of back and forth on it. There's been a lot of litigation in other states related to the CARES Act, not so much in Oregon that I'm aware of. But there's varying opinions and interpretations on the CARES Act, and we'll talk about that in a minute here. All right, so when to use a 10-day non-payment notice? Okay, so in my opinion, and I'll just say this right now, a 10-day notice should be used sort of as an overarching theme when the landlord is not subject to the CARES Act, and I'll explain why in a second. But that's sort of kind of a bigger thing, because if you are subject to the CARES Act, then you're going to want to use a different type of notice. We'll talk about that in a second. But if you're not subject to the CARES Act, so you've got no Fannie or Freddie mortgage, no federal program that you're subject to, so like LIHTC home or a HUD project base, and the property, you're not evicting a Section 8 voucher holder, then using a 10-day notice is appropriate, or when the landlord only wants to demand rent. So this is important because this is an error that I see all the time, and I want everybody to sort of understand kind of the points that I'm hitting home here. A 10-day notice can only demand full units of rent. Okay, so if your tenant's monthly rent is $1,000 a month, but your tenant paid you $500, so there's still $500 outstanding, you could not use a 10-day notice for that because there's a partial payment there. You've got a problem there with respect to partial payments, and once you have a partial payment and you've accepted it, the landlord cannot move forward with a non-payment of rent notice under 90.394. The landlord can still do a for-cause notice for the remainder, and that's the appropriate approach. But a straight 10-day notice is not appropriate there anymore because of the partial payment. Similarly, you cannot include things like late fees or utilities in your non-payment of rent notice. Okay, so that's for those of you who have properties that straddle the river. Washington is a little bit different than Oregon, so do not convert your Washington thinking down to Oregon. Oregon, rent is rent. Utilities are not rent. Late fees are not rent. Late fees are not rent in Washington either, but rent is rent in Oregon, and that's it. So that'd be things like your base rent, storage charges, parking charges, pet rent. Those things are rent in Oregon. Okay, so they can be included in your non-payment of rent notice. Things like utilities and late fees cannot. Okay. Some tips with respect to drafting and serving 10 days. We talked a little bit about that just a moment ago, but remember that 10 days can only be served on the 8th day of the rental period. For most of you, that's going to be on the 8th day of the month. 99.999% of the time, your rental agreements are going to have rent due on the 1st. And so that means you can serve a non-payment notice on the 8th day of the rental period. If your rent due date is different, and again, I'm not talking the day that rent is late, I'm talking the day that it is due. If your due date is something different than the 1st, then obviously your timelines will adjust. As I stated above, you cannot include the remaining balance after the partial payment. If a landlord accepts a partial payment of rent, the landlord cannot include that remaining balance in a non-payment notice unless there's a written agreement with a date certain for payment of the balance. That's a partial payment agreement. That's the exception there. Keep in mind this, that your Section 8, if you've got a Section 8 tenant, and that tenant receives, has a voucher and you receive payment pursuant to that voucher, that does not count with respect to the concerns, because the payment from the housing assistance provider is going to be different. We would just be talking about the tenant's portion there. Okay. The other thing to keep in mind here with respect to drafting your own non-payment notices is that you should only include sequential months during which $0 of the tenant's portion of rent was paid. And this circles back a lot of times to what I would call most of the concerns that I see with respect to notices, and that's improper application of payments. Okay. And so I'll run through this once with respect to application of payments, because it's important. But it also confuses a lot of people. So keep that in mind. So let's say, for example, your tenant's rent is $1,000 a month. Okay. And let's say they do not pay you for March. They pay you $500 for April, or they pay you $500 in April, and then they pay you nothing in May. What would happen, and that application of payments, the way it would shake out, application of payments in Oregon requires the landlord to apply any payment first to outstanding month's rent, then to current month's rent, then to utilities, then to late fees, and then to any other charges. If you're looking for the statutory authority for that, it is 90.220, and that is in subsection 9. So in my example, the way that it would apply is that $500 payment that was made in April would actually apply to March. It would actually, because again, going to outstanding month's rent, it would actually go to March. So what you would have is you would have $500 of March rent still outstanding. You would have $1,000 for April outstanding, and you would have $1,000 for May outstanding. So what does that mean if you're drafting up your non-payment notice? Well, that means that you could draft up a non-payment notice for April and May's rent. $2,000 would be the rent demand in there. And that would be a valid notice. The additional $500 that's due and owing from March, you would need to serve a for-cause notice for that. Alternatively, if you wanted to be simple about things, and this is probably what I would recommend, is you could just do a for-cause notice for all of it. You could do a for-cause notice for the $1,000 for May, $1,000 for April, and the $500 for March. That's still outstanding. Either way, that would be fine, but that would be how things would work out in terms of application of payments. Alrighty. And finally, this is a big one, folks. So make sure, and this goes back to updating your forms. HB 2001 requires a new statutory disclosure. Okay. So the new statutory disclosure, the HB 2001 disclosure, is required. It is required on all fiscal notices. Okay. So if you're doing a fiscal notice that demands payment, make sure that you have that disclosure. That disclosure looks like this. Okay, that's what it looks like. So make sure that any fiscal notice that you serve has that. Otherwise, it is defective, and there is no way around that. If it's not in the notice and the court sees that, the court will dismiss your case on its own motion. Okay. Finally, for folks who have Portland properties, remember that you are subject to a variety of other laws and rules, namely the Portland Fair Ordinance. The security deposit ordinance portion of that requires that you serve the PHB rental history form and ledger with all termination notices of any kind. Make sure that you do that as well. So that's just for Portland properties. Okay. Any questions with regard to 10-day notices? Just want to pause and break here.
There was a question about slides. I just want to direct everyone back to the chat where I dropped the link to the first handout. And when we move on to the second handout, I will drop that link. If for any reason you're having trouble accessing the documents in that link, send us a chat and we will be able to get those to you. And we do have a raised hand, Brad.
Cool. Who's raising their hand? Let's see here. How in the world do I do this?
Here, I think Adam. All right, Adam, you've been allowed to speak. So please feel free to unmute and.
Awesome. I just had a quick question. It sounds like the for-cause notice is obviously superior in terms of flexibility and utility. So why use a 10-day at all? I fail to see any useful application for that notice.
It's a good point. Here's and not really adding any context, because the context for my answer here is going to be related to some stuff that we're talking about later, which is sort of the perpetual cure period that happens. The benefit to using a 10-day at this point is pretty limited, as you've sort of noted. The only time that it would be beneficial in my eyes is if there's a good chunk of rent that's due and owing. So like the tenant hasn't paid for, let's say 3, 4, 5 months. Then it might be best to use a 10-day notice just to try and get into court quicker. The reason to use a for-cause notice in a lot of circumstances is because of the new sort of added complications of HB 2001, which is the perpetual cure period. And what that means is that the tenant, pursuant to HB 2001, can basically pay off everything that's due and owing in the notice. And I say in the notice, very hard and specific, because it's in the notice. And if they pay off what's in the notice, they get to stay. That is sort of the new perpetual cure period / redemption right that tenants have under HB 2001. So let's say, for example, we're just talking 1 month worth of rent, right? So you've got your tenant hasn't paid you for 1 month. They also owe you utilities, and then they also owe you late fee, a late fee for that month. Well, then it probably makes sense to use, a for cause notice if your goal is to try and move towards possession, because that requires the tenant to pay more, right? If the tenant owes you 3 months worth of rent or 4 months worth of rent at, let's say at $1,500 a month, I mean, that's going to be a hefty sum. So your tenant probably isn't going to be able to pay that or redeem that as easily as, say, $1,500. So to answer your question, is there a benefit to using a 10-day? In certain circumstances, yeah, but the benefit is not as good as it used to be, unfortunately.
Awesome, thank you.
Jerry had a question here. It says, please define Portland properties. Is that county specific or city only? So that is city of Portland only, but the thing to remember with respect to city of Portland is Portland has some unincorporated parts of the city that are not subject to the Portland ordinance. And the way that I determine this is if you go to Portland Maps, Portland Maps is kind of what I use to determine whether or not property is subject to the Portland ordinance. A lot of times what you'll see is property that kind of is in the southwest Portland area, kind of straddles the Washington County area, so to speak. A lot of those properties are unincorporated in unincorporated Portland, and they are not subject to the Portland ordinance. You do have some of those same sort of property issues down in the kind of the Clackamas county line area. There's some unincorporated parts of Portland down there, but you're just talking Portland proper. So anything that's in unincorporated Portland is not subject to the Portland ordinance. All right, and we will continue forward here. So the new notice, or one of the new non-payment notices for folks that still want to use a 10-day notice, but they are subject to the CARES Act. There is a 1030 notice. You'll see that form with some of the forms makers. As you kind of heard Adam and I talking back and forth, what I would say to this is that the utility of this notice is negligible at best. I don't think that the 1030 should be used at all, to be honest with you. I think simply using a for cause notice is going to be your best bet here. So I'm really going to kind of skip through this because, again, I don't believe that this notice has much utility, if any. Basically, what you're buying is 4 days from a cure period, but as I indicated, there is sort of a perpetual cure period now, which doesn't make a ton of sense. But that's kind of why this doesn't have a ton of utility. Again, property subject to the CARES Act. So this would be your folks that have a Fannie or Freddie mortgage. This would be your folks with the LIHTC or the home programs, the HUD project-based things. There is some debate with respect to whether or not a property that has one Section 8 voucher holder, whether that triggers the CARES Act for the entirety of the property. And you're going to find disagreement with respect to even attorneys that talk about this sort of thing. In what I will say is this, as I litigate in both Washington and Oregon. In Washington, I would be a bit more scared of this argument than I would be in Oregon. That said, it is an open question as to whether one Section 8 voucher holder triggers it for everybody. The language of the CARES Act is certainly poorly written enough and certainly broad enough to get to that reading. There is other guidance and sort of argument that even HUD doesn't think that they have that sort of authority, that they have the ability to do that. But it's an open question. What I will say is this: if you're at all scared of the CARES Act, just use a for cause notice, okay? Because a for cause notice by itself is going to be compliant with the CARES Act, okay? And that's all I'll say on that front. The rest of this is the same as what we talked about. Basically here, should I just serve a 30-day for cause non-payment notice instead? You should, yes. It has a slightly longer cure period, but it allows you to include other amounts like late fees, utilities, damages, all sorts of other things that you couldn't include in a straightforward non-payment notice. So again, if you're subject to the CARES Act, or if you have any concerns about the CARES Act, just use a for cause notice and you're going to be set. All right. Again, that new statutory disclosure, just make sure that your for cause notice also has that disclosure on it. Okay, that's important because without it, the notice is going to be defective. All right. So now we're talking about those for cause notices, that 30-day non-payment notice. You know, again, it's still an option. Most cases, going to be a better option for you. It allows you to demand payment of non-rent items. So things like late fees, utilities, damages. It also allows you to include partial payments. Okay, so keep that in mind. With respect to partial payments, for any of you that do draft your own notices, important to understand allocation of payments. And again, I talked a little bit about this, gave you an example. But one of the things that I often see that concerns me about notices, and I know clients get frustrated, but I have to bring it up to them, is, you know, when you see a notice, you know, I'll see a notice that will be along the lines of the example that I provided, right? So tenant's rent is $1,000. You know, tenant doesn't pay anything in March, pays $500 in April, and then pays nothing in May. So I'll get a notice, you know, that will basically state that exact same thing, right? It'll say that, you know, May $1,000 is due. It'll say April $500 is due. It'll say March $1,000 is due. Well, that's an incorrect allocation, right? Because again, the allocation of payment statute requires that payment to go to the outstanding month's rent. It goes back to apply to March. And so that can render your notice subject to attack or challenge on that basis. Now, is it a huge risk? Depends, right? There's still clearly May's rent that's due and owing that we know is accurate. The other 2 months, you know, there's clearly $1,000 due and owing for 1 month. There's clearly $500 due for a different month. So would a judge overlook that? Yeah, probably. I mean, I could certainly argue it. But making sure that your notice is factually accurate in what it states is due and owing is going to be important because, again, remember, there's tenants attorneys all over the place these days, and they're basically looking to challenge your notices at every step of the game. And if your notice is challenged, then that can present an issue. All right, so we've got a good question here, and this is one that always comes up. What if the tenant gives us a check and the memo says April rent? Do we still have to apply it to March's rent? This is a fantastic question because I don't know the answer to it. It hasn't been litigated. We don't have a response or anything from a judge on that front. So how do we handle it? Well, in this instant, I've kind of gone back and forth on this, to be honest with you. And my answer kind of changes here and there. I don't mind applying it to March's rent in that instance. And I also don't mind applying it to April's rent because I think both arguments have merit. Personally, again, I go back and forth on this. It's such a 50-50 thing to me. Personally, in this instance, I actually don't mind applying it to the April rent. And the reason, and I'm just going to show you kind of why I'm waffling. I'm going to pull up the actual statute and I'll show you what the statute says. All right. So here's the actual statute on my screen. And if you scroll down here, so, and this is the reason that I waffle on it. is here's the language of it, right? It says, notwithstanding a provision in a rental agreement regarding the order of application of payments, a landlord shall apply tenant payments in the following order. And then it lists it out. Well, in your example, this isn't anything in a rental agreement. It's a tenant directing the application. And so that presents sort of an odd scenario. Because, well, here, let me preface my answer. If you have a rental agreement that says what the application of payments is going to be, then I would defer to what's in the rental agreement. So here's how things would go. I would defer to the statute. Okay, so defer to the statute first. And then as long as your rental agreement is in line with the statute, then go with what the rental agreement says. If you don't have an application of payments provision in your rental agreement, then you're going to want to do what the tenant's directive is on the payment. Okay, so that is my answer to you. It will depend on what it says in your rental agreement. All right, let's continue on. All right, so drafting of for cause notices, of these 30-day non-payment notices, these can be served on the 5th day of the rental period. If the notice demands the current month's rent, it cannot be served prior to the 5th day of the rental period. Otherwise, it can be served on any day of that month. Just stick to the 5th. It's going to be easier for purposes of arguing it and having a judge understand it. Okay. The notice must itemize with specificity. So this is important right here too, is that, and I see this all the time, I don't like notices that basically just state, you know, you owe XYZ amount of dollars, and the cure is pay XYZ amount of dollars. Well, that may pass the smell test in some circumstances, and it may not in others. The other problem is that you may have amounts in that, you know, in that bulk amount that could be subject to waiver. And if you have amounts that are subject to waiver and your notice is not itemized, it can defeat the entirety of the notice. If your notice is itemized and it basically carves out, you know, May's rent, this amount, April's rent, this amount, March's rent, this amount, you know, these utilities, this month's utilities, and it itemizes them. Well, just because one itemized item is defective doesn't render the rest of it defective. So that's why I prefer itemization in terms of your notices, because it can save your notice. It can save your notice bacon, so to speak. Okay. All right. And again, that new statutory disclosure is going to be required. So again, make sure that you have that on your notices. It's important. The additional requirements for Portland properties, we talked about that. And then if you've got HUD subsidized properties too, make sure that you have those. So you referred to a 30-day notice on the 8th day of the rental period and just now on the 5th day of the rental period. When can you serve it? 30-day notices are on the 5th. The 10-day notices are what's on the 8th. All right. Continuing onward, again, we're talking about the statutory disclosure. Must be included with all of your non-payment notices. Again, I'm going to keep hammering that because it's you do not want to have your notice go down in flames when you do not have a disclosure form. Okay, so updating your forms is going to be important. The disclosure must be served with the FED summons. We take care of that when we file your evictions for you, so don't worry about that. No disclosure means no eviction for non-payment. Again, this is a fatal defect and the court can dismiss it will dismiss your eviction on its own motion if you do not have a disclosure in there, okay? All right, so that was notices, non-payment notices. Any questions about that? Because what we're going to do now is we're going to switch gears with respect to the eviction process, talk a little bit about what's happening there. All right. No questions. Let's continue on. All right. So there's some new requirements, some new funky oddities that are going on with respect to evictions due to HB 2001. So we'll talk about them here. There's a new requirement. The possession declaration has to be in all evictions. So in order to obtain a default judgment, so if your tenant doesn't appear, landlords must now file a declaration or testify under oath at the first appearance that the landlord has no knowledge of surrender. So the landlord must swear or declare under oath that the landlord does not have knowledge that the tenant has delivered possession, and that the landlord reasonably believes the tenant remains in possession. Okay, so a couple of things about this, just what we were doing at least at the start of cases is we were having our clients sign these declarations just when they sent us over the documents, and that was all hunky-dory, until some judges had some problems with us filing them at the start of cases, because they said, well, a couple of weeks went by now, which is how long it takes to get into court. So the tenant may have surrendered in that time. I think that's kind of BS. But the takeaway is that judges are starting to want to see these declarations signed closer to the date of the first appearance. Okay, so the moral of that story is having people file your FEDs. If you do that, it's important to basically be responsive to them if they need that close to the first appearance date, because again, the closer we can get to the first appearance date, the less likely a judge is going to be upset with the amount of time since you signed the declaration. It looks like Adam has another question. Go ahead.
I was wondering if you could expand a little bit on surrender and exactly kind of how that's defined.
Yeah, it's a good question. So surrender and kind of the circumstances surrounding surrender are defined in 90.147. So taking a look at that statute, obviously the surrender of keys is a big one, right? That's sort of a huge sort of takeaway where the landlord can retake possession. Odds are you're not going to have that, right? So what can you do on that front? Go ahead, serve your notice of intent to enter, and go and take a look and see if people are still there. If people are still there, obviously, that's very clear that there's been no surrender, right? If the property is full of items and the tenant's personal property, yeah, in that point, obviously there's been no possession, right? But you may get in there and you may find nobody, you may find nothing. Okay, well, if that's the case, then under all the circumstances, you could probably retake possession and the eviction would not be needed. Odds are you're going to find yourself in that gray area quite a bit, right? And that's the problem, is you're going to find yourself in a situation where there's a couple of things here and there, maybe a couch, maybe a mattress on the floor. In that circumstance, I probably would continue with the eviction. I would say that there's been no surrender. There's been no, the tenant hasn't vacated. There's potentially still people living there, and kind of see how things shake out. If the tenant later comes back and says, I'm out, I was out the whole time, well, cool. Then we can just vacate the default judgment and, we've gotten what we wanted. But you're going to find yourself in a gray area quite a bit. And what I would recommend, if you find yourself in that gray area, take pictures of what's in the unit. And that'll help you paper the file and, potentially push back on any sort of contention that there was a surrender. All right. Continuing forward with non-payment timelines, these have been extended, unfortunately. It used to be that we could get into court as early as 8 days after the filing fee was paid for non-payment cases. Now the first appearance is scheduled at least 15 days after the filing fee is paid. So that extends things quite a bit. In a lot of circumstances, it extends it by 2 weeks because certain courts only do their eviction first appearances on particular days. Multnomah obviously being the exception. Multnomah does them every day. Places like Washco and Clackamas. And I think, I don't know how Marion does it since we file in Marion Justice, but Marion Justice does theirs, I believe, once a week or maybe twice a week. I'm not quite sure. But again, you can see how that gets things stretched out quite a bit. Keep in mind that FEDs that are not non-payment based, so conduct-based evictions, those are still on the old timelines. So with those, you can still get into court 8 days after the filing fee is paid. With respect to trials, these are now at least 15 days after the first appearance. For non-payment cases, it used to be that the trial would be set no later than 15 days after the first appearance, unless there was a stipulation. Now, non-payment trials cannot be scheduled any earlier than 15 days after the first appearance. They must be scheduled within 30 days after the first appearance. So you see how things are getting a little bit extended in terms of timelines. All other FED trials can be scheduled within that 15 days after the first appearance. So again, conduct-based evictions still on the old rules, still on the old timelines. All right, so a couple new defenses that that we need to be aware of in terms of things that tenants can do to complicate your FEDs, your evictions. One, the landlord failed to reasonably participate with the rental assistance program. So this is sort of a callback for all of you that are used to or remember what it was like during COVID. We were required to participate with a rental assistance program. Now that is also a requirement. We have to participate. A landlord who fails to reasonably participate with a rental assistance program will be deemed to have caused the tenant to not tender rent. This results in a dismissal of the FED. So you'd lose the case. So what does it mean to reasonably participate? I can't really tell you other than I can tell you just give them the docs that they request. If they request a W-9, give them a W-9. If they request a ledger, give them a ledger. If they request a rental agreement, give them a rental agreement. You know, and you want to do this by way of email. So keep that in mind. You want to do this by way of email so that you have a paper trail that you can prove that you provided what you said that you provide, so that we can push back, because I see this defense all the time. Even when it's asserted in bad faith, even when there's nothing backing it up, the tenant will always say that we failed to cooperate. And so that's why it's important to have that email, because then you can say, no, I actually did. Here's the email where I sent them what they asked for. And that's it. Other landlord actions that cause the tenant to not tender rent. So here's another defense. We don't really know what this means. You know, it's not the landlord's failure to participate with rental assistance is not the exclusive basis, but you know, time will tell what this actually means. But I'm sure tenants will cook something up. What's the effect of it? The dismissal of the eviction. So if this defense is found to be accurate, then the eviction will be dismissed, and we will lose, and then you know, we'd have to start the process over. We'd be liable for the court costs and attorney's fees, assuming that the tenant has an attorney, and the tenant again would retain possession. So we would not be able to retake possession of the property. All right. So again, the post termination right to cure the non-payment notice. So this is the perpetual cure period. So this is one of the dumber things that I think HB 2001 has done, you know, among many things, but it's just the unfortunate reality of things now. There is a perpetual right to cure. I would argue that it's up till trial, could be up until judgment enters. But if the tenant covers the amount that's in the notice, so if they pay you what's in the notice at any time up until that point, they're entitled to stay. Okay, so this sort of harkens back to what Adam and I were speaking about earlier. If your tenant pays you everything that's in the notice, and this is another reason why it's probably best to use a for cause notice, because you can include other amounts in there, then the tenant, gets to stay if they can do that. But the more that you can put in there, utilities, late fees, those sorts of things, again, assuming they're not subject to waiver, that's going to be a little bit more challenging for the tenant to overcome. So if the tenant tendered or caused to be tendered rental assistance or any payment covering the non-payment amount owed under the termination notice, the judge must dismiss the case. So that means that the tenant would stay in possession. Again, important point, the tenant only has to cure the notice, not the balance, not the total balance. And I see this a lot with some clients that use just straightforward 10-day notices. The tenant may be back 5 months of rent and utilities, and they may just put 1 month worth of rent in the non-payment notice. Well, still a good notice. It's a valid notice. You don't have to demand everything. But if you don't demand what you can, the tenant has an easier cure path, that perpetual cure path. So, that presents a challenge sometimes when the tenant shows up and says, here's your check for 1 month worth of rent. If the tenant can do that, then the case is dismissed, but they're not entitled to attorney's fees or costs, and we are entitled to charge the tenant for the filing fee, which in Oregon is $88, but we're not entitled to any service fees or other costs or attorney's fees. So that's unfortunate. That's the reality of HB 2001. Presents some headaches, presents some challenges, and especially that perpetual cure period. Okay. The summary, sort of some quick takeaways. A non-payment termination notice isn't even really a non-payment termination notice anymore. The cure date isn't a cure date. Weeks or even months after both the cure date and termination have passed, the tenant will be able to cure the notice and resurrect the tenancy. The landlord will have to absorb those attorney's fees incurred and can only charge the tenant for the filing fee, and the process will have to start over again with the rents that have accrued in the interim. Now, I say that time will tell in terms of how landlords respond to this. And what I mean by that is there's some sort of unique quirks in Oregon law that we may be trying to kind of push back on this. Time will tell, with respect to how those are litigated and how those shake out. But we've got some tricks up our sleeve too. I'm not going to talk too in depth about them right now because we're still sort of fleshing the arguments out and trying to figure out whether we can get some good test cases for them. But we've got some tricks up our sleeve too, so stay tuned for those. And I would venture a guess in a few months we'll know how those things will shake out. All right. So again, here is the disclosure form that I've been ranting and raving about. Again, make sure that you have that. Make sure that that's included with all your non-payment notices, because if it's not, your notice will be defective. All right. Any questions on that before we jump into SB 611? Where is the disclosure form located? It's on this lecture handout, so you can take it from there. I think you can also find it on the Oregon Judicial Department's website, although I'm not sure. I haven't looked for a really long time. I think that's where you can find it. Again, I'm not sure. But if you need it, again, you can pull it right from the lecture handout and copy and paste it on your notices. How do we get the handout? I think there you go. Should be on the should be on these links here.
And if you have any trouble accessing the handout, again, please send us a message and we will get you a different link. But again, both the handouts are dropped in the chat, handout 1 and handout 2. I believe Brad is about to move on to handout 2.
All right. Any other questions with respect to HB 2001 and the chaos it causes? One final takeaway just with HB 2001, folks. evictions are becoming much more extended and much more prolonged. I understand your frustration on that. I really do. Unfortunately, there is nothing that I can do to change that. So, you know, while I can certainly sympathize with you, you know, whoever is handling your evictions for you, just remember that there's nothing that they can do to change it. It's just sort of the unfortunate reality of things. You know, good news, I guess, if you want to see a silver lining, is that Washington's process is much more extended. And in Washington, from what I've heard up in King County, their sheriff's lockouts, even after you get a judgment up there, or a writ, their sheriff's lockouts, I think, are about 60 to 90 days out. So that's even after you win, it's still 2 to 3 months out. So not that extended here after we get a judgment in Oregon. I think we're about 3 weeks out with the sheriff in some circumstances, but that's about as long as it can get. All right, so on to SB 611. So SB 611 is the new sort of rent increase rules that they have not been signed by the legislature yet, but they will be. And once they are, they will be effective immediately. So it is important to talk about them right now. All right. So the rent increase rules in Oregon are under 90.323. That's the statute that talks about rent increases in Oregon. The important point that we'll touch on here going forward is, again, Portland has its own set of rules that are different from the state. So if you have Portland properties, keep in mind that your rules are going to be slightly different, but those differences are important because of how SB 611 is going to work. Okay. All right. So basics of rent increases in Oregon, these are going to remain the same during any tenancy other than a week to week. The landlord may not increase the rent during the first year after the tenancy began. So you cannot increase rent in year one. Okay. So keep that in mind. At any time after the first year of the tenancy, you must give the tenant written notice at least 90 days prior to the effective date of the rent increase notice. Keep in mind, most people just mail them, so it's going to be actually 93 days, because remember, for mailing, you have to add 3 days for mailing. Okay, keep that in mind. This is sort of the big change right now. Okay, so this middle box here is going to be important because, as you know, right now, at least with the current state of the law, not taking into account SB 611, the maximum rent increase in Oregon right now is 14.6% because of the way that the law is written. The 7% plus CPI. CPI basically is a measure of inflation that the feds do and calculate. CPI this past year was 7.6%. That took the maximum rent increase under the state law to 14.6%. That will change. And Adam, I'll get to you in a second here after I'm done chatting about this section here. The SB 611 change basically is going to cap the rent increase at 10%. So a maximum of 10%, and it is the lesser of 10% or 7% plus the change in CPI. So what you're looking at there is, you know, whatever the CPI is, you're going to have to take into account, and it's going to be the lesser of that. You can find the CPI at this link here. That's what they've got. The state cap is published annually. They have it there. And so that's going to be kind of the thing. So keep in mind, and I'm going to hammer on this later, but I'm going to hammer on this now. Okay. Remember that Portland's maximum rent increase is 9.9%. It's not 10%, it's 9.9%. Okay. So if you have property in Portland and you raise rent by, let's say, for example, let's say that the CPI is, you know, 4%. So that would mean that we'd be capped at 10% under the state law. Well, if you raise rent by 10% in Portland, you have triggered the relocation damages, assuming the tenant notifies you that they want relo. Okay, so again, keeping that at 9.9%. Let's talk about the flip side. All right, let's say the flip side of things occurs, and let's say the CPI is low. So let's say the CPI is 1%. Okay, so we would not trigger the 10%, right? We would trigger the lesser, which would be 7 plus 1%. So your maximum rent increase under state law would be 8%. So your maximum rent increase under Portland law would also be 8%, because if you tried to go to the 9.9 under Portland, you would violate the state law. So you wouldn't want to do that. Okay. So that's kind of where the confusion is going to lie a lot of times in the future, because Portland just decides to do its own thing, and the state legislature lets them. The Oregon Supreme Court also lets them. But it's going to require properties that are in Portland to be very aware of what the CPI is. Okay, so I hammered on that here. I'm going to hammer on that again, because that's going to be important. The other thing, rent increase can only occur once during per 12-month period. Okay, so that's sort of a change in kind of the what was sort of a confusing and sort of not really defined point of Oregon law, whether or not you could increase rent twice as long as you stayed under the cap. You can only increase rent once per 12-month period. So that's going to be a change as well. All right, Adam, yeah, your question was first.
Thank you. Actually, two quick questions. Number one is we saw here that the provisions are based on the assumption that SB 611 will pass as written. Will all of this go into effect like immediately after SB 611 passes, or is that like a start of Jan 2024 sort of a thing?
Yeah, it's going to be immediate, unfortunately, at least as written. And so if you look up, you can actually look up kind of what the status of things are. So here's where it is on the legislature's website. So if you look at measure history, this is where it's at. It's been recommended that it pass. And so the current text is right here, is B engrossed. That's kind of what we base this lecture handout on. And so if you pull up that B engrossed, here it is. And here is sort of the implementation statute. This 2023 Act takes effect upon its passage. So they're not going to change that language. I would almost guarantee it. If they do, fantastic, but they're not going to change that language, I would imagine.
Second question I had for you was the first year, we're not raising rents in the first year. We don't violate that first rule. Is it acceptable to submit the 90-day notice that rents will be increased at the start of the year within that first year, though? Could you send that notice out immediately?
Yeah, so that's a separate question here that Julia had in the in the chat. That's how it's done. Yeah, that's how everybody does it. So I have no problem doing that. All right, so on to Bree's question here. When should I deliver the rent increase notice? Tenants have been in the property for 2 years. After the first year, gave the rent increase effective November 1. Like to increase the rent again when the opportunity presents. Again, same sort of question here. So you know, as long as the increase occurs, you know, during that. You know, you can serve the rent increase notice the couple months in advance, as long as it, you know, it increases during that that next kind of year cycle. So I think that's the same question that everybody's kind of driving at. So all right, on to Bridget's question. What are the current laws for when properties transfer ownership and the new owner would like to start with new tenants? What kind of notice does the new owner need to give? If keeping the current tenants, what is the percentage of rate increase the new owner can charge when creating the new rental agreement. So this kind of deals with stuff that we're not really talking about in this lecture setting here. That basically, if the property changes hands and sort of a new owner comes in and comes in to be a landlord, they're going to inherit those new tenants. There's not really a notice that you can serve with respect to, hey, new landlords coming in, so they want new tenants, so everybody needs to get out. So keep that in mind. The new owner is going to be subject to the same rules as the old owner. So if there's an ability to do a no cause or non-renew, then that new owner is going to inherit sort of that right. They're not going to be able to just reset things. Okay. All right. When do we expect this to pass? I'd probably say, I don't know. But I would anticipate within the next month or two. I don't have my pulse on my finger on the pulse of things on that front, but I would anticipate pretty soon. All right. Continuing on. All right. So 2 exceptions to the rent cap. The first certificate of occupancy for the dwelling unit was issued less than 15 years from the date of the notice of the rent increase, or the dwelling unit is regulated by affordable housing by federal, state, or local government, and the change in rent does not increase the tenant's portion of rent or is required by program eligibility requirements or by a change in the tenant's income. Important with respect to these exemptions, folks. If you're looking at an exemption, do not automatically assume that you're subject to one. It's important to get that right. So keep that in mind, because if you violate it, then you're going to trigger damages provisions from there. And it's also pretty tricky sometimes with respect to that first certificate of occupancy. Okay, so keep that in mind. The other thing is that the notice must expressly claim the exemption and state the facts that support it. So even if you're subject to the exemption and your notice doesn't state anything about it, your notice is invalid and you violated the state law. Okay, so again, if you think you have an exemption, you should work with an attorney on that, because it's going to be important to get that right. All right. So quick other question here. So if the old landlord did not raise rents in the past year, the new owner can come in at a 9.9% increase with a 3-month notice right away, correct? Again, assuming all those facts line up, then yes, if there was no rent increase that occurred in the last year, then the new owner, the new landlord, comes in and they have all the rights that the old landlord would have had. It's just a switch in landlords. It's not a switch in anything sort of related to the tenancy. But keep in mind, 9.9% in Portland after SB 611 might not be 9.9% anymore. Okay, just due to that CPI switch. So keep that in mind. Again, it gets tricky, but you want to get that right. All right. Additional rules regarding rent increases. Your notice of rent increase must specify the amount of the new rent, the amount of the increase, and the effective date of the increase. And when I say all of those things with the amount of the increase, it needs to say your new rent your rent will increase $35. So it must state the increase. It must state the amount of the new rent. So with that $35 increase, your new rent will be, X plus 35, X being whatever the old rent is. This new amount, the effective date of this increase is this date. It must state those things. So again, getting a form off the internet is not really probably going to be your best bet, folks. So that's where I again hearken on. Make sure you have good, solid forms, okay? Because if you violate the state law, the landlord is liable for 3 times the monthly rent plus actual damages subject to the tenant. That's a pretty punitive hit for something that probably isn't, isn't that bad, but that's what the legislature wants to do. They want to punish technical issues. So that's what they're doing. All right. All right, with respect to Portland, some other obviously notes with respect to Portland. The landlord must pay the tenant relocation assistance. If the landlord triggers relo, there's certain triggers to relo. If the landlord in Portland serves a 90-day no cause or 90-day no cause notice, a 90-day with a QLR, or a no cause non-renewal. So keep that in mind. Again, this is not really a no cause section, but this is just, that's for reference. Again, this is the big point we were talking about before with respect to Portland. In Portland, a notice of a 10% rent increase will trigger relocation assistance. So another relo trigger is a rent increase above 9.9%. 10% is above 9.9%, folks. So keep that in mind. This is Portland and the state trying to trick you with respect to your Portland properties. Even if the state rent increase cap is 10%, that Portland lower threshold is going to apply. So any 10% increase is going to trigger that relocation requirement if the tenant triggers it. Okay. The tenant has to demand that relocation assistance, and there's certain rules that apply therein. So I'm not gonna delve into that too much. But again, Portland properties, and I can't stress this enough, it's going to be confusing with respect to Portland properties. So working with an attorney, working with somebody to keep you on the straight and narrow there, it's going to be important. In Portland, those revocations and rescinding of notices don't work. That's why it's important to get this right the first time, because any violation of the Portland ordinance triggers the potential issue. So if the tenant requests it, it's not going to be a situation where you can pull it back. So again, getting that right the first time. There's some additional statements about relocation assistance and things like that. The other important thing to keep in mind here is that in Portland, any rent increase that you serve in Portland, you must include there's an additional Portland disclosure that you have to include, the notice of tenants' rights. You have to include that with every notice of rent increase. Okay, so keep that in mind. I can't hammer that home enough, because if you don't, then the Portland ordinance has been violated and you may have a damages issue. Okay, so again, in Portland, there is an additional disclosure of the notice of tenants' rights that's required. It looks like we hit that here. All right. If you do end up paying the Portland relo for anything, for any requirement, keep in mind that you do have an obligation to notify the city of Portland of that within 30 days. Okay. All right. So that's rent increases. Again, this is not the current law, but it will go into effect. This is going to pass. If it doesn't, that would require several of the Democrats having a change in heart, and I don't see that happening. So preparing for this is going to be important. All right, any questions about that? How about a question here? How about rent increases between tenants? Do you mean after a tenant moves out? So I think that's how I interpret your question. So with respect to between tenants, as long as the landlord didn't serve a no cause notice, then the tenant can, or the landlord can basically can set the rent at what they want. But if the landlord served a no cause notice, then the landlord is limited to the increase that's allowed under law. So just checking real quick here. Yep, so here's the provision of the law. They just switched the numbering. I just wanted to check to make sure that all they were switching was the numbering. So it's the same as the current law, that a landlord, it says a landlord terminating a tenancy with a 30-day notice without cause as authorized by 90.427, sub 3 or sub 4 during the first year of the tenancy may not charge rent for the next tenancy in an amount greater than the maximum amount the landlord could have charged the terminated tenancy under this section. So a couple of interesting little quirks there, obviously. One, remember Portland, there's no such thing as a 30-day no cause, it would be a 90-day. So does that trigger the same rule? Probably. I would probably just go with it just to, to be safe. But for things like QLRs, let's say you're doing like a QLR for, substantial renovation or repairs, then no, this rule wouldn't be triggered and the landlord could basically reset the rent to whatever they wanted to. But remember, keep in mind, if the tenant serves you a no cause notice, or you terminate the tenancy through eviction, then it's not triggered, and you could basically reset the rent with new tenants for whatever you wanted to. Again, assuming that provision doesn't change in the final bill, which I don't think it will. But again, just keeping in mind that what we're working off of right now, I would guess is going to be the law, but there could be slight changes and things like that. They're not going to change anything substantive, but certain little things may change. And truth be told, I could see that being one of those changes. I don't have any information on that, but again, it's important to just check with the law, check with an attorney before you do that, just to make sure that you're not violating any of the laws. All right. Question: if sending the rent increase notice now, should it be based on the new law? That's a good question. I mean, I don't think it needs to be, but here's the thing: if you want to play it safe, you certainly could. I don't have any reason to believe that the law will change to be basically retroactive, and the law would have to basically state that it's retroactive. But again, that could be one of those things that I could see them adding something like that in at the last minute. So if you're sending a rent increase now notice now, certainly. If you don't want to have to redo it for any reason, that's probably a good idea. But keep in mind, if you served one now and they added some quirk in, it wouldn't subject you to any damages, because that would be sort of an ex post facto law. You would just need to redo the notice. It wouldn't, it wouldn't expose you to any liability there. So I don't mind it either way. I think you could serve a new notice now based upon the current law and be just fine. But does complying with sort of this law, as it's written now, even though it's not passed, does that hurt you at all? No, it doesn't. Doesn't hurt you at all. So all right. Any other questions? All right. If there's no other questions, I think that's it.
Fantastic. Thank you so much, Brad.
No problem. Thank you, everybody, for joining us today.
Yeah.
Hope everybody learned a little something. If not, if anybody needs anything, I will put my email, since my email is not on the lecture handouts. Here is, oops, I think I messed that up.
And while Brad's doing that, I just want to draw everyone's attention. We do have upcoming classes. We've got our Using Oregon Realtors Forms training, which is free to all members. On Monday, or on May 22nd, which is today, from 1 to 3. We also have another webinar on Friday about land sale contract and memorandum. getting into, again, Oregon Realtors forms. And then on May 30th, we have the free law and real required course for all members. So just to let you all know, those are all coming up. Please feel free to get registered, and thanks again so much for attending. You'll get your CE certificate or you'll get an email with instructions on how to access it in the coming days.
Erica, it doesn't look like I can type my my email in here anymore. I think after I
Interesting.
try it, here we go. I'll try it in the chat here. There we go. All right, so my email is in the chat, folks. Couple of things to keep in mind. Yeah, you know, if anybody needs anything, first and foremost, there's a lot going on right now, so immediate help is challenging. There's not too many of us that do this area of law, so you know, response times can be delayed a little bit, so keep that in mind. Second, I am going to be gone on vacation for my anniversary next week, and I will not be returning till the following week. So if anybody needs anything and they need anything quickly, it probably is not going to be able to happen. Finally, if you do email me and you need something, it's important to state that you were at a lecture that I gave, because that does sort of trigger desire to take on those sorts of clients and that sort of work. We're a bit jammed up right now, but we're still staffing up. But if you came to me through a lecture, odds are I'll respond to you. But again, keep in mind, responses can be delayed through certain things. I am going to Hawaii, actually. So my wife tricked her into marrying me, got her to stick around for a year. So I guess she probably deserves a trip to somewhere tropical. So.
Well, we hope you have so much fun in Hawaii, you and your wife, and congratulations on your anniversary. I think we had a webinar either right before or right after you got married last time. So, well, love that.
She keeps coming back. I don't know. She'll wisen up eventually, I'm sure, but you know, she's a good sport. So, but yeah, she deserves something special. So.
Oh, yeah. Well, thank you again for your time, Brad. And thank you again, everyone who joined us. And we will see you. And we will be having another class with Bradley on November 6th, I believe is when we settled on that date. So
I think so. Yeah.
That'll be on our class emails as always. So we look forward to seeing anyone who wants to attend there as well. Have a lovely rest of your day, and we'll see you all soon.
Take care, everyone.